Hi, my name is Natasha Budimski and I am a solicitor at Mellor, Olsen Lawyers, and I practice extensively in the area of personal injury claims for people who have sustained injuries in motor vehicle accidents. I have a particular focus on people who have sustained brain injuries, and I find that the CTP system is quite complicated as it is, and when someone has a brain injury, it just adds an extra layer of complexities to it, and there is a particular way that I think brain injuries need to be dealt with under the scheme that we currently have in SA. So I've put together a bit of a CTP Basics or 101 presentation for people who are going through the CTP system and might just need a bit of an idea about what things to keep in mind, what's part of their claim, and I've sort of tailored this presentation towards both advocates or service providers, as well as towards claimants who might not be aware of what their entitlements are, what they should be doing. So this is the first time I've used Zoom for a presentation, so hopefully this works, but I've got some slides here for us to sort of go through whilst I'm talking at the same time. Perfect, it works. So CTP Basics. So as most of you might be aware, from the 1st of July 2013, there were significant changes made to the legislation here in South Australia, which surrounded personal injury claims and specifically motor vehicle accident claims. One of the biggest changes, well, two of the biggest changes, was firstly that there was an introduction of certain thresholds that people had to meet in order to have a compensation claim or to be able to receive a monetary amount for certain heads of damages, whereas prior to the changes there were no thresholds. Someone could, if they were injured in an accident, they could just easily make a claim for their personal injuries without having to meet any particular thresholds. The second biggest change was the introduction of the ISV scale, which I'll talk about in shortly in my next slide. But aside from the thresholds, the rest of the system sort of remained the same, other than thresholds and the ISB, in that we still have a fault-based system. So in order for someone to have a successful claim, someone else needs to be at fault, whether it's the other driver or the driver that's of the same vehicle that that claimant is in. There needs to be an at-fault driver in order to have a successful compensation claim. The exception to this is if someone is on the lifetime support scheme or makes an application for the lifetime support scheme, which I'll talk about at a later stage of the presentation. It's also important to note that the compensation claim, whilst it's obviously against the other driver, it's managed by the other driver's compulsory third-party insurer. Now, compulsory third-party insurers, that is run through when someone goes to register their vehicle. So generally when you go online and you go to register a vehicle, you have a choice of which compulsory third-party insurer you wish to have your car insured with. Previously, under the old system, we only ever had the one insurance company, which was Allianz, but in recent times that has now been divided into between 5 insurance companies, which is Allianz, Amy, Berkshire Hathaway, QBE and SGIC. And again, it purely depends on whoever the at-fault driver is insured with as to who you will be dealing with for a compensation claim. So moving on to the next slide, the ISV. So the ISV, like I said before, also came into operation on 1 July 2013, and it's basically a tool that lawyers and insurance companies use to assess the damages for non-economic loss in relation to injuries that have arisen from a motor vehicle accident. It basically covers, it's a large, comprehensive, detailed scale that covers every injury that someone can have to every single body part that they can sustain from a motor vehicle accident. It then allocates those injuries to an item number, and then within that item number it has an ISV range of 0 to 100. So 0 being very, very minor, 100 being obviously very extreme, serious, severe injury. So the purpose of the ISV is to reflect or try and reflect the injuries at the person's level of injury and the adverse impact it has had on the injured person. It's not an easy thing to do, and a lot of the time a number does not describe enough the exact sort of level of impairment someone has or the symptoms that they're having. But unfortunately, with the system we have, it's the only way that we can try and measure a person's injuries and to see what sort of thresholds a person does or does not meet. So that's the way we assess the ISV here in SA at the moment. So as I've sort of mentioned before, the ISV number that is allocated to a person corresponds usually to a dollar amount for non-economic loss damages. This is particularly so for sort of pain and suffering or voluntary services, something along those lines, and it assists in determining what thresholds apply under those heads of damages. It's very important that ISV assessments are undertaken at the right time, and they shouldn't be undertaken until an injury has stabilised. And for that, we rely on the treating medical doctors and also to a certain extent the independent consultant doctors to advise us when a person is stable or isn't stable. The ISV assessments can only be undertaken by an accredited assessor under the CTP scheme. That's very important because the scheme is quite complex and there is a certain formula and a certain way that the assessors determine what ISV is relevant to that particular person. They also use a particular medical journal or medical guide to try and determine the whole person impairment. So if you really need to use a doctor who's accredited in those areas, you can't just use a local GP or any other treating physician. It needs to be someone who's accredited under the scheme. It's also important that any medical ISV assessor has in front of them all medical reports, medical notes, treatment notes, plans, all those sorts of things, because that will assist them in determining the ISV. They take into account a lot of aspects of a person, so the treatment that they've had, the symptoms that they've been reporting throughout the claim, whether or not their injuries have improved at various stages, so all those sorts of things. So it's very important that any medical assessor who is going to be providing an ISV report is provided with all those documents. So that's a little bit about the ISV. I have on the next slide, which I'll flick through now, an example of the ISV scale when it comes to brain injuries. So here I've got the ISV number for minor brain injuries, which is item number 8. And as you'll see within item number 8, it's got various factors that need to be taken into account by the accredited assessors, as well as the lawyers and the insurance companies when determining whether or not someone fits into this category. As many of you probably appreciate, brain injuries aren't often that straightforward. Everyone sort of experiences, everyone who's had a brain injury experiences symptoms differently. And they might tick some of these boxes, but they might not tick all the rest. They might have other symptoms that might not have been included in this descriptor. So to that extent, the ISV is very limiting, but there are ways around it, which I'll discuss later on. But here's an example of where a minor brain injury is, and you can see that the ISV range that is given is between 6 and 20. So 6 is on the lower end of the range, which means someone probably wouldn't meet some of the thresholds under the CTP scheme, whereas 20 is at the higher end of the range, and if someone met that high end of the range, they likely would meet the majority, if not all, of the thresholds needed for to claim for various heads of damages. Again, where someone is within that range between 6 and 20 depends on what their symptoms are. It's not a straightforward question. or answer, really. It all just is on a case-by-case basis, and it also just depends on their symptoms and whether or not they meet the symptoms purely in this category or whether they meet the symptoms of another category as well. So moving on to a moderate brain injury, which is a number 7. And this one has been divided into 2 separate subcategories, 7.1 and 7.2. And the reason for that is obviously when they were putting the ISV scale together, they realised that there are varying degrees of a moderate brain injury. So there's 2 different ranges. The 7.2 has a range of 21 to 40, and 7.1 has a range of 41 to 55. So obviously 7.1 is a more serious moderate brain injury, whereas 7.2 is probably on the lower end of the range, or a less serious moderate brain injury. Again, there's some descriptors or some factors in there that need to be taken into account when assessing if someone falls within this category. In my experience, generally speaking, someone with a fairly severe or symptomatic brain injury that does affect their daily lives usually does fall within the moderate brain injury category, and they generally do meet a lot of the thresholds, and obviously they fit within the range from 21 and above. So moving on to the next one is the serious brain injury, which is item number 6, and this one carries a range of 56 to 70. So again, this just highlights how it sort of goes up and up and up on the ISV range, and it's all about trying to figure out where someone sits within the ISV scale. Again, they've got some descriptors and examples that will, or factors that would affect an ISV scale within this category. Again, I'm of the view that it's very general and very basic, some of the symptoms and factors that get taken into account. It's on a case-by-case basis. Someone can uplift, which I'll probably explain a bit more later on, but what I mean by uplift is a doctor might assess someone as being in a moderate brain injury category, say 7.1, but they might actually have additional symptoms that might actually overlap with the symptoms or factors that are here in the serious brain injury category. In those situations, if there's consistent comments throughout the medical reports and medical history of someone fitting into this category, but also moderate brain injury category, you can, when negotiating with the insurer, seek to uplift or bump up someone to a serious brain injury if that is more reasonable to do so. It has happened, and I have had examples myself and seen examples of that happening. And insurers generally are quite realistic and reasonable about that, especially if there's consistent medical evidence on that. It's only when there's sort of differing opinions from various doctors that it might become an issue. But generally speaking, it's fairly reasonable to expect that an insurer will allow an uplift or someone to move into the next category above if the medical evidence supports it. So the next category is the extreme brain injury, which provides a range of 71 through to 100, and the item number on the scale is number 5. So again, this is quite an extreme, severe brain injury, and I think when you're actually at this point, when your injuries are at that point, the ISV range isn't a huge factor, as someone would have clearly met all the thresholds, and the only reason why you would sort of fight about or argue or really want to determine the ISV range is because that would affect the damages for someone in relation to pain and suffering. Because as I'll sort of explain shortly, the ISV range, so between that 71 and 100, a number between there will allocate to a dollar figure on pain and suffering. Okay, moving on to the next slide, multiple injuries. So it's often the case that someone sustains more than just one injury in a motor vehicle accident. Under the scheme, the dominant injury is the one that determines someone's ISV rating or ISV number. But when there are multiple injuries, we do focus on what the dominant injury is to figure out where someone rests on that ISV scale. But the multiple injuries are still taken into account, and they can often be used to, like I said before, uplift someone into another category if the multiple injuries all have an adverse impact on that person, and if it also kind of increases or explains the severity of the symptoms if there's multiple injuries. I've always found it interesting that sometimes the brain injuries aren't the dominant injury when there are other physical injuries to look at as well, which I've always found quite interesting. I guess it just depends on the item number of the injuries and the ranges that they provide. You would think normally the brain injury would be the dominant injury because of the effects that it can have on someone, but yeah, sometimes the other physical injuries can become the dominant injury unexpectedly. But either way, all injuries are assessed together within the claim and when you're looking at settlement negotiations. Moving on to the next slide, ISV thresholds. So as I've been mentioning at the start, or from the start I should say, there are thresholds that have been introduced with the CTP scheme. So I've just outlined what the thresholds are here. So pain and suffering, someone needs to have an ISV number of 11 or more. So that's the number that's within that range. So whether it's item number 6, but then a range of say 6 to 20, they need to have an ISV of 11 or more to claim pain and suffering. Future economic loss, an ISV of 8. Gratuitous services and loss of consortium. There needs to be an ISV of 11 or more, but there is the additional threshold that for someone to claim gratuitous services, it needs to be, they need to have received care from their partner or family member for at least 6 hours per week for 6 months consecutively. So that's an additional threshold, which is a difficult one to match, particularly if someone is getting care from other service providers, or it might be that they can't have this, for whatever reason, their partner or relative can't do the 6 hours per day, but they might be doing it for maybe 4 hours per day. So it's a bit of a harsh threshold, that one there, I think. And the other threshold that was introduced with the new changes was that in order for the insurers to contribute towards anyone's legal costs, the claim has to settle for $25,000 or more. Prior to the changes, there were no thresholds in relation to legal costs, and usually the insurers would always make a contribution towards someone's legal costs regardless of the settlement amount. So that one was pretty harsh as well, that threshold. So if for whatever reason someone does not meet the thresholds, or one or all of them, but they have still suffered ongoing symptoms or loss of income, they can still make a claim for compensation under the principle of it would be harsh and unjust if they didn't receive a compensation amount. Even though the changes came through in 2013, we still haven't had any cases go through the court system. So we actually don't really know what would qualify as harsh and unjust from the court's perspective. And unfortunately, that's what we kind of need to be able to advise clients whether or not they have a claim that would fit under that principle. I think a lot of people would, but that's my own personal view. But so I haven't actually seen that one come in yet or come into play, but hopefully we'll get something like that soon. Generally speaking though, in my experience, most people with brain injuries will meet one or more of the thresholds. And I think it would be pretty harsh and unjust if someone who did sustain a brain injury, whether it's a minor brain injury or a more severe one, if they didn't meet the thresholds, that they wouldn't be awarded some sort of compensation. It's important for me to note that the ISV is irrelevant for heads of damages such as past economic loss, past and future medical expenses, and future paid services. So you can claim for those things irrespective of what your ISV number or rating actually is, which is good. So there's no thresholds or limits that apply to that. The next slide is in relation to the lifetime support scheme. So that also was one of the changes that came through, but that came a little bit later. It came in 2014. So this lifetime support scheme was brought in to cover those who had sustained severe injuries from a motor vehicle accident and required lifelong care because of those injuries. It's a no-fault scheme. So what that means is that even drivers who are at fault for a car accident can actually come onto this scheme and have their treatment paid for. Whereas under the old scheme, if you're at fault for an accident, you could not make a claim for your medical expenses or pain and suffer or anything like that. No fault, so drivers at fault still can't claim for any CTP scheme benefits like pain and suffering or economic loss or anything like that, but they will at least have under the lifetime support scheme, if their injuries are serious enough, they will still have the ability to claim care expenses and treatment expenses and all those sorts of things. Applications for to become a participant of the lifetime support scheme have to be made within 3 years of the accident, which generally isn't an issue because if your injuries are serious enough, the application will happen either whilst someone's in hospital, by a relative or a social worker, or by a care provider. So the types of injuries that apply for someone in order to be able to access the lifetime support scheme is spinal cord injuries, moderate to severe, brain injuries, severe burns, amputations, and blindness. They're the main injuries that someone needs to have in order to qualify for the lifetime support scheme. And the whole purpose of it, like I said before, is for it to provide necessary and reasonable treatment, care, and support to anyone who's injured in a motor vehicle accident. There are two types of participants in the scheme. There's a permanent participant and there is an interim participant. A permanent participant is usually someone whose injury is obviously that severe that they qualify to stay on the scheme for life, which means they'll have their medical expenses paid for, their care expenses paid for, and run through the lifetime support scheme. An interim participant is someone who, for a short period of time, has had a severe injury but have obviously improved over time and no longer need the lifetime support scheme to continue to fund for their treatment. Majority of my clients who have brain injuries and are on the scheme have usually transitioned on to become permanent participants. I haven't really had someone who's just been an interim participant as yet. I'm sure that will come up at some point, but generally speaking, people with brain injuries from car accidents or severe brain injuries from car accidents become permanent participants on the scheme, which is good. The benefit of the lifetime support scheme is that firstly it covers everyone in the sense that even drivers at fault can get some benefits for their medical expenses by the lifetime support scheme. But the other thing is you can still have a CTP claim and make a claim for pain and suffering, economic loss, and perhaps some past voluntary services. And then the lifetime support, and then they also have the lifetime support scheme where they can have their future medical treatment and care paid for. So you can have both at the same time, a CTP scheme and a lifetime support scheme treatment funded also. So it's just important to know though that if you do have a CTP claim whilst being on this lifetime support scheme, you can only claim for certain heads of damages such as the economic loss and pain and suffering. You wouldn't be able to claim from the CTP insurer for any medical expenses or any care services, but sorry, specifically paid care services, as that's already covered under the lifetime support scheme. It's also important to note that the CTP insurer want to know if the lifetime support scheme is involved and if someone is a permanent participant before they look at finalising the claim. It's probably also, chances are the insurer will want to see or receive a copy of the Lifetime Support Scheme file at some point during someone's CTP claim as well, purely because that just goes towards trying to just determine the injuries and the level of the impact of the injuries. Moving on. So the role of the advocate in CTP claims or lifetime support scheme applications as well. I think the reason why this is important is because given the current scheme that we have, with someone who has a severe injury like a brain injury, they need someone, such an advocate with service providers from such as Brain Injury SA, to help them complete the CTP form, kind of liaise and attend all their medical and legal appointments, just so kind of acts as a bit of a middleman, I guess, to a certain extent, make sure that the right information is getting across to everyone that correctly, to the doctors, the lawyers, to the insurance company, communicate with the lawyers and the insurers about making appointments and sharing relevant medical information, ensuring that the client is receiving proper funding for treatment. That can occur by, communicating with the lawyer about what needs the client is telling the advocate that they need, or if the advocate is talking to the client's medical practitioners or attending appointments and there's treatment raised during those appointments, the advocate can then contact the insurance company or contact the lawyer and make requests for that treatment to occur and for that to be funded by the insurer. Basically to sort of help, I guess, the client understand the claim process and what stage their claim is at as it progresses. I think the advocate is also an important tool to consider what material is being requested and obtained by the insurer, and they can sort of monitor that a little bit. We solicitors do that as well, but if an advocate is going to be dealing with an insurer directly and being that middle person, the advocate needs to be aware of what information is being requested, and if it sounds like it's a little bit of a fishing expedition. So if an insurer, for example, is asking for 20 years worth of medical records or copies of someone's, just randomly say, Department of Child Protection or Education file, even though the person has finished school many years ago, you might think, well, that's a little bit of a stretch and might not necessarily be relevant to the person's claim. So to probably monitor the requests that are made by the insurers is another important role for advocates to have. It's also important to know that advocates should not make any legal decisions on behalf of the client, such as accepting any settlement offers or entering into negotiations for settlement offers. If someone has the capacity to make legal decisions and they're unrepresented, they should be, the advocate can be present there if the client wants, but the advocate shouldn't be the one making the decisions on behalf of that person. If they are, that kind of raises questions about that person's or the claimant's capacity about understanding the process and whether or not they should be making these decisions for themselves. It's important that if an advocate is to be involved, that perhaps legal advice is sought or legal representation is actually obtained and sought before entering into settlement negotiations. And if there's any concerns about a person's capacity, legal advice should be obtained about whether or not a litigation guardian, whether it's a professional litigation guardian or a family member, also be appointed. So the next slide I have is what to watch out for when dealing with insurance companies directly. As I said before, monitor correspondence from the insurer and particularly between the client and the insurer directly, especially if you're dealing with someone who has a brain injury. I haven't had anything recently, but I do know for a period of time there, I myself had received several comments from clients saying that when they were dealing with insurers directly, the claims managers were making comments to them about how they don't need a lawyer and their claim won't be worth much and they don't pay for legal costs anymore, all of which is incorrect, especially when someone has a brain injury. if the insurer is making those sorts of statements or being difficult, I would advise to take notes of those sort of conversations. So the date, the time, what was said, when it was said, and also try and limit things to any communication to be in writing via email with the insurer. And then if you have a genuine concern about comments being made to you, you can make a complaint. Either the advocate or the claimant directly can make a complaint to the CTP insurance regulator. And on my slide, I've got their details there when you can do that. The other option you have as well before making a complaint is to get legal advice about whether or not the comments that the insurer is making is correct, and whether or not a complaint should be lodged or not. So the next slide is when to see a lawyer. Good question. In matters involving brain injuries, generally speaking, I sort of am of the view that legal advice should be sought early on. The only reason why I say that is because I still find that insurers are struggling to understand people with brain injuries and the effects that it has on people. You need to make sure that from the start, a person who has sustained a brain injury is getting the correct treatment, and that there is communication going on between the insurer and the doctors and anyone else involved, so including an advocate who might be acting on that person's behalf through brain injury SA. I have seen instances where solicitors weren't on at the start and the right treatment wasn't being funded for, and that sort of resulted in a delay in the person's recovery and their condition becoming more chronic because the correct treatment just simply wasn't funded for at the start. So I often find that if you have a lawyer on board who specialises in CTP claims and who also understands brain injuries, that aspect of the claim could sort of be rectified early on. The other thing as well is I find that insurance companies, like I said before, they don't really understand brain injuries. So they will make appointments and thinking it'll be okay to make an appointment sort of later in the day, 3:34 for an intense medical appointment or assessment, or for an occupational therapist or something along those lines, without realising that by that point of the day, a person with a brain injury might be completely fatigued. They can't concentrate. They're exhausted. So the whole process is a waste of time, and all that happens is the person with the brain injury gets frustrated and fatigued even more. And as a result, the assessment might not actually reflect the correct condition of the claimant. So I find that those little things still need to be explained to insurers, and I think if you have someone on board who understands a brain injury a bit more, those sorts of things can be eliminated and the process can go a lot more smoother. I would encourage people to find law firms at the start of claims who perhaps do 30-minute free consultations, because that might help someone decide whether or not they want to proceed with a lawyer, or whether or not it's worthwhile for them to manage the claim with an advocate or their family member for the first 6 months, and then touch base with a lawyer later on during the claim, and perhaps get a lawyer at a particular point during the claim. That might eliminate some legal costs, especially if someone's not comfortable with having a lawyer early on, which is understandable. So perhaps try and find law firms who are happy to do the free first consults. But the other thing as well is I would say to keep in mind, if you have a moderate to severe brain injury, it's best to get a solicitor on early on rather than later, like I said before, just to avoid any issues arising during your claim. And it also depends on the relationship that the person has with the insurance company. It's also important for me to note that a person with a moderate to severe brain injury may also not have capacity to make decisions. So it might be that an advocate or a family member needs to, at the start, make some inquiries with the solicitor about getting that person assessed for the purposes of capacity and to determine if they have capacity to instruct. And if they don't, getting formal orders from a court appointing someone litigation guardian for that person because again, that could affect a personal injury claim if that isn't done early on. So moving on to tips. Look, there's probably a few tips that I could go through, but one of the main ones I've sort of highlighted is keep good file notes and good records. With advocates, it's important to remember that your records probably are discoverable, and I can imagine insurers would request copies of those sorts of records. So make sure when you do keep the records that what you're writing is clear and concise, and you're not putting anything in your file notes that perhaps shouldn't be there. Maintain and update a list of all treatment and service providers, because chances are the insurers will want to see what treatment is being provided to the claimant, whether it's reasonable, and they'll probably will want to request reports from from anyone actually who has dealt with the injured person. For advocates and family members, with a client or a partner who has a brain injury involved, so attend the appointments, attend the legal appointment. Be involved in the information sharing with both the insurer, the client, and the lawyers. Don't be afraid to reach out, and if you want to request funding for certain things, I think it's important to make those requests to see if they can be funded. There's no harm in doing that. And I guess the big one is, if you're ever in doubt about someone's claim, whether it's your own or whether it's your partner's or whether you're an advocate on behalf of someone, if in doubt, just seek legal advice. Sometimes it might be just a simple question and you won't need to proceed with a lawyer. Other times it might be a little bit more complicated. But I think it's just, if you're in doubt, just ask for that advice and that'll help you a lot. So I hope that has helped sort of break down the CTP system and the ISV scale that we currently have, and given you some tips on what to do if you're handling a personal injury claim on behalf of someone as an advocate or a family member or as a client. And if you have any questions, I've got my details here on the slides. Feel free to keep in touch, and thank you for listening to my first Zoom presentation. Thanks everyone. Bye.